The first thing is that Mr. Gates testified and told you all that he does have a continuous relationship with his child's mother, Miss Katia Dent, and I told you all in opening statements that you'll be introduced. The first thing is that Mr. Gates, I apologize. So you'll be introduced to Ms. Dent. And Ms. Dent is the link between Mr. Reeves and Mr. Gay. Because of this consensual relationship with Ms. Dent, Mr. Reeves and Mr. Gay had continuous back and forth conversations over the phone, back and forth threats over text messages. But on this particular day, Mr. Gay told you all he was just dropping off his daughter. He didn't engage or want to engage in a physical altercation with Mr. Reeves. He didn't tell Mr. Reeves to meet him at this location. He didn't even know Mr. Reeves was going to be at this location because he was just dropping his daughter off as he was told by the child's mother. Now, ladies and gentlemen, what's important, as I mentioned yesterday in opening, is the quality of Mr. Gay's testimony, because that's what matters in this case, was the quality of the evidence that was provided to you, which was the testimony. Mr. Gay told you all that yes, he does have a contentious relationship with his child's mother. He told you all and was truthful about the relationship between, or the lack of relationship between him and Mr. Reeves. They were constantly going back and forth on the phone. It was constantly, contentiously toxic between Mr. Reeves and Mr. Gay. Now, ladies and gentlemen, when you all deliberate, you will be receiving these instructions, jury instructions for assault and battery. All I'm asking you to do, ladies and gentlemen, is take the testimony that you've heard from Mr. Gay and connect it to the elements of the crime. That's all. And as we talked about yesterday, you need to pay attention to every instruction on that jury instruction and connect the testimony that you heard with those jury instructions of assault and battery. Now, ladies and gentlemen, again, the reasonable doubt comes into play when you all are deliberating. Because we're not talking about a possible doubt, we're not talking about an imaginary doubt, we're not talking about what could have happened, what should have happened, what should not have happened, right? We're talking about the facts and the facts only, and the testimony that you all heard from Mr. Gay. Now, what I also want to point out is that Mr. Reeves decided to take a stand yesterday. Now, when Mr. Reeves took the stand, in his testimony, he told you all that he's now with Mr. Gay's child's mother. They're in a relationship. They're a family. They live together. The family man resides in a suburban area. But ladies and gentlemen, I want you all to pay attention to the fact that if Mr. Reeves was a family man, he wouldn't have time to meet up with Mr. Gay and engage in a physical altercation. He wouldn't even have time to engage in a back and forth conversation and arguments with Mr. Gay if he was a family man. A family man would let Mr. Gay and Ms. Dent solve their problems between themselves by themselves. They wouldn't engage and interject and try to put themselves in the situation between a child's mother and a child's father. That's not Mr. Reeves' place. And it wasn't Mr. Reeves' place to go to their grandfather's house to meet Mr. Gay and engage in a physical altercation. Ladies and gentlemen, again, the jury instructions will instruct you on what the elements of the assault and battery is. And the elements will lead you to your verdict. And I'm asking you to return that verdict of guilty of count 1 for assault and battery for Mr. Reeves. Thank you, ladies.
On behalf of the
Good morning again, everybody.
Good morning.
Good morning. So I agree with the people. Thank you so much for making it back out. Thank you for the sacrifice of time and everything that you could have been doing. You chose to do what you're supposed to do and be here. So thank you, Mr. Reeves. Thank you very much. And he thanks you for having listened attentively yesterday. He thanks you for being an intelligent jury. He selected you himself as his juror. So he thanks you for having listened and having paid attention to everything that has been presented to you. So I guess I'm trying not to be all over the place with this, but this one was a little bit hard for me to piece together. So please just bear with me. I would agree with the people that the evidence did show that there is a very contentious relationship between Mr. Gay and between Mr. Mr. Gay though testified that he drove up to the scene, gets to the parking lot, and he sees Mr. Reeves kind of standing at a distance. It's a big parking lot that he gets to. He gets there and he sees Mr. Reeves at a distance, and he sees Mr. Reeves, what Mr. Gay described as doing some stretching motions, and I think he even said like he's getting ready to fight, and we're gonna get back to that. And Mr. Gay's response to that is not to, he says he went there to drop his daughter off. He doesn't look over there, see Mr. Reeves looking kind of strange, and they already have this strange relationship that's going on. He doesn't just say, you know what, I'm here to drop Skylar off. There's a big parking lot, let me go over here and get into over here someplace away from where Mr. Reeves is, call the grandfather and say, come out here and get Skylar. This is some interesting stuff that's going on right here. He doesn't do that. He pulls up and he said he didn't even have an opportunity to park.
Pause. I apologize.
No problem.
Okay, I apologize.
No problem, Judge. Pulls up, doesn't have an opportunity to park, jumps out of the car. He doesn't even have time to get into a parking spot, and he gets out of his car. That's very strange behavior for somebody who only went over to that location to drop the daughter off. That's because that is not consistent. That doesn't make any sense. Now, if you remember, as I was asking Mr. Gay about whether or not he had any conversation with Ms. Dent earlier before he went over there, before I could even get my question out good, he blurts out himself, we didn't talk about me going over there to fight or nothing like that. I didn't even ask him anything about that. He volunteers that information himself. And so we explored that a little bit. And I asked him, were you planning on going over there to fight? And he said, no. I'm like, well, why did you say that? He couldn't give you, not me, he couldn't give you a good answer to that. That's because that is exactly what he planned to do when he went over there that day. That Mr. Gay had his daughter in the car, and he goes over to the grandfather's house intending to fight Mr. Reeves, who he had been harassing for years, who he, by Mr. Gay's own admission, had been threatening, had a very negative and contentious relationship. Mr. Reeves testified to you that on the day of the incident, that he believed he was having a conversation with Ms. Dent, and he believed that Mr. Reeves took the phone from Ms. Dent and said, don't be talking to my girl like that. Okay, so Ms. Ritter talked to you about what Mr. Reeves placed in this situation. Is it Mr. Reeves' place that if the person he's in a relationship with, the person he lives with, that person has a child with somebody else, and that man is calling, yelling at his fiance on the phone, cursing at her, threatening her, and you heard the messages that he said, he admitted that he sent. We'll go back over that. Threatening her, yelling at her, cursing at her. Is it Mr. Reeves' place to kind of be there at the house and know that that's going on? And just, that's their business. Is that what he's supposed to be doing? I don't think that we think that's what he's supposed to be doing. Is it okay for, Mr. Gay talked about being antagonized, that they're antagonizing him throughout the course of their interaction. And I asked him, like, what are they doing to antagonize you? And one of the things he said that they were doing to antagonize him is that when they go to drop off Skylar, Mr. Reeves is in the car. So when Ms. Dent goes to take Skylar to visit her father, when she takes Skylar to visit her father, not trying to keep the baby away from her natural dad, not trying to interfere with their relationship at all. Ms. Dent takes Skylar over to spend time with her dad, and the antagonism that Mr. Gay describes is that Mr. Reeves is in the car. Why can't he be in the car? This child's mother, when she's going over to drop the other child off with somebody who has threatened Ms. Dent, who has yelled and cursed Ms. Dent, to the point where, by Mr. Gay's own testimony, at some point, they blocked him. Ms. Dent was like, you're not just gonna keep calling your husband at me and threatening me and all this. But Mr. Gay said that at some point, Ms. Dent blocked him. Why isn't it okay then, when Ms. Dent goes to drop off Skylar? How come it's not okay for Mr. Reeves to ride along? That's not antagonizing. Mr. Gay needs to move on. Mr. Gay is upset, and this is what I talked to you about in opening, that he's upset about the fact that Skylar, you have a little girl, you're not with her mom anymore. Why isn't it okay for her to get a whole lot of love? Why isn't that all right? I was thinking about this yesterday, and I have a friend who's actually my daughter's friend. This young lady was having a problem with an employer, a male employer at work. Into tyrannical and I remember this young lady, she was telling me about the situation, and she says, I don't know who he thinks he's talking to. I got two dads. And I thought about what she was saying. Her parents got separated. So she had her natural father, but then her mother got remarried, and she has a stepdad too. So she has two dads. What's wrong with this little girl growing up having the love of two dads? What's wrong with that? What is the problem that Mr. Gay has with that? He should be thankful that there's somebody in his daughter's life. He can't be there for whatever reason. And, we talked a little bit about, they took his parental rights away from him. He didn't go to court. There's no testimony, no evidence that he went to try to go through the courts to try to reestablish the relationship. He didn't testify to that. But why is Mr. Gay upset about the fact that there is another man in his daughter's life who is helping her to learn how to tie her shoes, helping her to learn how to ride her bike, helping her to go to school and grow up to be a happy woman? Mr. Gay should be thankful for that. But he's not. He is very, very, very jealous. And I guess in a way it makes sense because he loves his daughter. But he's not in a relationship anymore with his daughter's mother. And he can't tell his daughter's mother who's going to be in the car when the mom goes to drop the daughter off. Nobody's trying to keep the little girl away from Mr. Gay. Testimony is that what Mr. Gay, I think, testified himself is that, again, they antagonize me when they bring my daughter to me. At the time of this incident, I think Mr. Gay testified that Skylar had been with him for about 3 days. So Mr. Reeves is not standing in the way of Mr. Gay having a relationship with his daughter. He's not doing that. There's no evidence to support that. So Mr. Gay testified that on the day of this incident, he sends at least 3 text messages to Ms. Dent. One of those text messages, he admitted that he said, come over here and I'll beat TF out of both of y'all. Another of those text messages, sit your pregnant ASS down and watch your boyfriend get his eyes closed. He admitted that. He sent that that day. Then he sends another text message threatening physical violence against Mr. Reeves and Ms. Dent. And then Mr. Reeves, he gets cloaked in the presumption of innocence. He has no burden of proof here. He doesn't have to take the stand, but he gives up his right to remain silent because he doesn't want you, the jury that he's picked, walking off thinking that he's some kind of assailant, that he just fights. He doesn't want you thinking that. So he gets on that stand and he tells you that Mr. Gay was threatening and harassing Ms. Dent and Mr. Reeves for years. And that on the date of this incident, he made direct threats to Mr. Reeves and to Ms. Dent as well. And that at some point, they're like, let's get this over. What is Mr. Reeves' place? To just keep getting harassed, to go to drop-offs of the daughter, and for Mr. Gay to go snatch her on the car door, trying to pull him out the car, keep calling his house and just acting ignorant on the phone? Is that to just continue to let that happen? Now, does it make sense to say, okay, you know what, let's just get together and fight it out? Probably not. But what's Mr. Reeves' place here? To just keep getting threatened by this man, to get his eyes closed and get TF beat out of him? He's just supposed to keep putting up with that? So Mr. Reeves testified that he's over at the house, at the grandfather's house, and that he sees Mr. Gay pull up, and that Mr. Gay pulls up and jumps out the car and walks toward Mr. Reeves and swings on him twice, misses, and that's where the fight goes. That the only other person that's there is the grandfather. That Mr. Reeves does not set up any ambush or anything like that. He doesn't, there's no other people that come in there trying to help him. There are people that come in to break up the fight. The fight. Not an assault and battery, to break up a fight, which Mr. Gay invited, which Mr. Gay threatened, which Mr. Gay egged on. Now, you're gonna get a jury instruction that tells you that an assault and battery takes place where there is an offensive touching, and the touching has to be against the complaining witness's will. How can that touching be against Mr. Gay's will when he invited it? When he's the one who said, I'm gonna close his eyes. When he's the one who said, I'm gonna beat TF out of it. How can that be uninvited? How can that be unconsented? How can that be against Mr. Gay's will? He set the whole thing up. He's over the course of years, by his own admission, threatening. That's the word Mr. Gay used over there in the other court. Threatening Mr. Reeves and threatening Ms. Dent, and admitting that he's threatened them both that day. So, when we come to court, the people have a burden of proof. And I always like to put up the little legal skills, right? So you match legal skills. And the defendant is presumed innocent. The defendant is presumed innocent. The defendant comes to court by our Constitution presumed innocent. That's why we have to go to trial. Can't just, it's not like the police come out to the scene and they make a quick decision right there and they're like, all right, you go to jail, you don't go to jail. It's not like that. When we get to court, the people now have a burden of proof beyond a reasonable doubt. And it is the prosecution's burden to remove the presumption of innocence away off of the defendant by putting enough evidence in those scales to tip the scale, not to the place where it's even, but to the place where now it's in favor of the complaining witness. And the people have not been able to do that at the very least at best here. If you believe everything, if you was, you're intelligent people, believe with your intelligence brings you to believe. But if you believe that Mr. Gay's story makes sense, because this is what we got, he said. If you believe Mr. Gay's story makes sense, even after, it looked to me like it didn't make no sense after cross-examination, but if you believe that Mr. Gay's story makes sense, but you also believe that Mr. Reeves' story makes sense, the scales now are even. If you believe that everybody's story, he said, they both make sense. If you believe that both stories make sense, the people have not met their burden of proof. If you believe both stories make sense, the scales are even, and that means the people have not met their burden of proof, and you cannot find Mr. Reeves guilty of assault and battery. You cannot by law find that the touching that Mr. Reeves admits happened. You can't find that touching was against Mr. Gay's will. The tie, I would say another tie. The tie goes to the defendant. If you believe it, it goes to the defendant. And I would argue absolutely there's not a tie. Mr. Reeves took that stand, and Mr. Gay's testimony, it kind of was going left, it was kind of all over. It was kind of difficult. Mr. Reeves took that stand and he told you what happened. He told you exactly what happened. Mr. Reeves told you that Mr. Gay invited him after threatening him that day. Invited him to come over to fight. Mr. Reeves goes over there. Mr. Reeves sees Mr. Gay. Mr. Gay approaches Mr. Reeves and swings on him twice, misses, and they fight. And a couple other guys up there break it up. That makes sense? Is that consistent with everything that's going on here? Does that make sense in light of the fact that we have a man who clearly loves his daughter and wishes he could be a better part of her life, and just is not able to make it happen for whatever reason? And that's not Mr. Reeves' fault. Mr. Reeves hasn't done anything to stand in the way of Mr. Gay having a relationship with Stephanie. And it's a sad situation. I hope that all gets worked out. Mr. Gay can just be okay. Started blowing up. And so I'm going to ask you.
Any rebuttal? Yes, sir. Ma'am. So, ladies and gentlemen, Ms. Stevenson came up here and spoke to you all, and what stuck out to me is that she mentioned strange behavior, right? So there was testimony from Officer Shakur yesterday that when he arrived to the scene on Myers Road, he spoke with Mr. Gay. He noticed that Mr. Gay had injuries, some lumps on his face, nose was bleeding, the nose ring was pulled out, he was bruised up, and this is consistent as to the testimony that Mr. Gay told you yesterday. He told you that he arrived at this location, saw Mr. Reeves, him and Mr. Reeves both got out of the vehicle, engaged in a physical altercation. Other people jumped in and started to assault him as well. Now, ladies and gentlemen, I point that out because there's consistency in the injuries and the testimony from the officer to what Mr. Gay told you all in the testimony yesterday. And what's also strange about the behavior that went on November 27th, 2022 is that when the officers arrived, Officer Shakur testified that he only spoke to Mr. Gay. He didn't speak to Mr. Reeves. He didn't speak to these other people that Mr. Reeves testified jumped or tried to break up the fight. Nobody was there but Mr. Gay. Now, ladies and gentlemen, again, this family man image that Mr. Reeves is painting to you all is false. A family man, if you were there to invite yourself to a fight that Mr. Gay wanted to engage with you, why not stay there and tell the police the story that you're saying that Mr. Reeves has, or Mr. Gay has been harassing Mr. Reeves, he doesn't want any contact with Mr. Gay has been threatening him. Why not stay and tell the police this side of your story? Mr. Reeves didn't do that. As he testified to you all yesterday, he just left. After the fight, he just left. He didn't stay and talk to any police. He didn't stay and try to make a police complaint. He didn't stay and show the police these threatening text messages from Mr. Gay, because that's not what's going on in the situation, ladies and gentlemen. The relationship between Mr. Gay and his daughter has nothing to do with the incident that happened between Mr. Reeves and Mr. Gay. Again, you heard from both sides, there's very contentious bad blood between Mr. Reeves, Mr. Gay, and Ms. Denton. But that's not why we're here. We're here because Mr. Reeves went to that location to meet Mr. Gay and assault him while he was dropping off his daughter to her granddaughter. Ladies and gentlemen, it's simple to follow the laws and the instructions that's given. And if you listen to the testimony yesterday, if you read those jury instructions, the only thing I have to prove to you beyond a reasonable doubt is that Mr. Reeves, he touched Mr. Gay without his consent. And ladies and gentlemen, like Mr. Stevens just said, Mr. Reeves testified, he gave up his right to remain silent, and he testified in there and took that stand. And he admitted that he engaged in this physical altercation with Mr. Gay, right? So half of my job is done. Half of those elements are met. He admitted it. He got on the stand and admitted that he got into the physical altercation. What's clear is that an invitation to fight or an invitation to meet up with somebody does not give you consent to touch that person. An invitation to a fight is not the same as a consent to be touched by another person. Ladies and gentlemen, I'm asking you to just follow those elements on those jury instructions and connect it with that testimony and evidence that you heard from people yesterday. This family man image, this wanting to be a good man to the daughter has nothing to do with the fact that Mr. Reeves went to this location on this day and physically assaulted Mr. Day. Those are two different things, ladies and gentlemen. Two different things. We're not here to discuss any family law. We're not here to discuss who has custody over who. That has nothing to do with the elements that I have to prove to you today, ladies and gentlemen. The only elements that I have to prove is that the defendant made a physical touching, whether offensive, forceful, violent, to another person, Mr. Gay, without his consent. That's all I have to prove, ladies and gentlemen. And that testimony, proven beyond that reasonable doubt, and I keep mentioning that and putting emphasis on reasonable, because I'm asking you all to use your reasonable common sense, your reasonable everyday experience to connect that testimony to the elements of this crime. And once you do all that, you all will turn a verdict of guilty. Count one off that. Thank you again, ladies and gentlemen.
All right. I'm going to use that right. Okay. Ladies and gentlemen, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all of the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer said something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law that you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your duty to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or a part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to make an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, or suggestions or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony to accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about other things, you may simply accept the part that you think is true and ignore the rest. When you discuss this case and decide on your verdict, you may only consider the evidence that has been properly admitted in the case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses. There were no exhibits, correct?
Correct.
Okay. So evidence includes only the sworn testimony of the witness. Many things are not evidence and you must be careful not to consider them as such. I will now describe some things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. The lawyer's questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I may have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. You have heard testimony from a witness who was a police officer. The testimony should be judged with the same standard that you evaluate any other person's testimony. The defendant is charged with the crime of assault or assault and battery. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery on Julian Joseph Gay. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant. That is, not accidental. And it must have been against Julian Joseph Gay's will. It does not matter whether the touching caused an injury. Second, that the defendant intended either to commit a battery upon Julian Joseph Gay or to make Julian Joseph Gay reasonably fear an immediate battery. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about November 27, 2022 at or near the location of 18,000 Myers Road in the city of Detroit, which is within the county of Wayne. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the court officer. It is not proper for you to talk directly with the judge, the lawyers, court officers, or other people involved in this case. Write a note, put it in an envelope. Don't write on the outside of the envelope, put the note in the envelope, close the envelope. Pass it to the court officer, you can slide it under the door. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return a unanimous verdict, do not reveal this to anyone outside of the jury room. That means if you write a note because you can't reach agreement, and you want to let me know that you can't reach agreement, the note should only say we can't reach agreement. The note should not say we can't reach agreement. It's 4-2, it's 5-1, it's 3-3. So don't put the voting on the note. When you go to the jury room, you will be given a written copy of the instructions that you have heard. As you discuss the case, you should think about all of the instructions together as the law that you must follow. You may return a verdict in this case as follows. The verdict form reads: the people of the state of Michigan, case number my name versus Martise Reeves. We, the jury, in the above captioned case by unanimous decision, find the defendant count 1, choices not guilty or guilty of assault and battery. So say we all, and the jury, the verdict form should be dated and then signed by the foreperson as well as a printed name, and you will be given, you each will be given a verdict form, but, it's only necessary for one person to sign that verdict form. Okay. Now. Only so dramatic. I'm sorry. What is the thank excuse? You're number one. So juror number one, this is what's gonna happen. Because it is early in the day, I'm gonna, be very, hopeful that your services will not be needed. However, while I am going to allow you to leave, did I show you? Please leave your phone number with the court officer, and in case of an emergency, we will have to call you back today. So if some emergency were to happen to one of the jurors, then we would call you and let you know that you need to come back. I would give you a depending on where where you are, where you've gone, I would give you, of course, time to come back to the court, and then the deliberations will go forth. I am going to go ahead and give you your voucher for the second day. You can let Ms. Flanagan know I need the voucher for juror number one. I'm gonna go ahead and let you take your voucher and all that, but please understand that technically you have not been discharged from jury service until the jury reaches. So once they reach a verdict, my clerk will contact you and let you know that you're discharged from jury service, okay? All right, thank you. Okay. So that was juror. Okay, my remaining jurors, we're going to give you your jury books as soon as I return. I'll borrow it from you. Make sure that books 2 through, well, this jury already told us who was the fourth. I don't know how they picked them, but just make sure books 2 through, I guess it's a good thing we didn't pick number 5 out the bag. Okay. Make sure that that they have, did you put the in book number 1? Did you put the verdict form in book number 1? Yes. So take it out of book 1 and just send it back to the room in case somebody needs it. All right, and then you are going to be taken to the jury room. After you get your notebook, in the notebook is simply all of the jury instructions that I read. So if anyone needs to reread an instruction, I believe that the elements of the crime are in the front pocket of that, and probably the verdict form as well. All right. Oh, do you have the envelopes?
Yes.
All right. So you're number 5, write a note and put it in the envelope if you want to talk to the court.
All rise for the jury.
Okay, so then just think you're number 1, I guess, just take her downstairs or something, or I guess she could sit in here. or in the hall.
Okay.
I will need her away from the parties because she's not discharged. So let her know it'll be about 10 minutes to get her out. All right, let's transition. Let's transition quickly to the other courtroom. I guess, so Officer Crafts, I'll just stay down. I'll go to the other courtroom and I'll stay down there. So any notes and stuff can, I'll be in regular.
Okay, so Judge, we do have a couple in person from Ms. Stevenson.
So yeah, we can, I'm sure Mr. Mooney has got his stuff together.
I was just saying, because I know you come to the courtroom as far as opening up.
Oh, okay.
We're not gonna look at that.